Now we're talking about water rights in that chapter. There are 4 water right terms in that chapter 5. Accretion. Accretion is the gradual buildup of land onto existing land. For example, you have waterfront property and the waves bring more soil, more sand onto your property and create sand dunes. The sand dunes were created by accretion. Now, the actual sand itself in that chapter is called alluvion, A-L-L-U-V-I-O-N. This here, A-L-L-U-V-I-O-N. So the process is accretion. The actual soil itself, the sand, is called alluvion. Okay? Now, another term in that chapter is avulsion. Avulsion is another, these are all water terms. Okay? Water terms, all right? Avulsion you want to think of as the sudden tearing away of real estate by nature. For example, with Sandy recently, the hurricane, where people lost their houses quickly, the key to avulsion is sudden, in not taking a long period of time. When they lose real estate by the sudden loss by Mother Nature, then they lost it by avulsion. Okay? No problem. So, accretion, the gradual buildup. Alluvion is the actual soil, and avulsion is the sudden tearing away of real estate by nature. Now, the only other term in there that you had mentioned is reliction.
I'll see you tomorrow.
Let's suppose that you own real estate by a lake. Let's say that this is the lake. Okay. And because of a drought, and one of these houses is yours. Okay. And one of these, and now because of a drought, the lake dries up. All the people around the lake are going to own the exposed property to the center of the lake. Okay? One of these. And the way that they're owning this extra property is through that term.
Reliction.
So reliction is where people own the exposed land under a body of water to the center of that body of water, if ever that occurs. The Corps of Engineers have to prove that that water has receded permanently. I mean, if it's going to come back again, obviously when it's all water here, people have the right to use the water for their enjoyment, for their boating, going fishing. But if they can prove that this water has receded permanently because of a drought, then underneath the water there's going to be exposed land. And these homeowners are going to own the property to the center of the water by way of reliction. They're going to be taxed more, but then their property is more valuable because they've added on to their property. So, in that chapter, it mentions also something about a fixture, and it also mentions something about a trade fixture, and you need to know the difference. So let's talk about them. The first one, a regular fixture. This is an item of a personal nature that has now been attached to the house permanently, and it cannot be removed. For example, almost everything in our house once was personal property, but the carpenters came in, put the cabinets in the kitchen, nailed them to the wall, becomes a fixture. More commonly, the one that we're most familiar with is the lighting fixture. When that fixture's in our car, it's personal property. When the electrician puts it in the dining room as a chandelier, it becomes a trade. It becomes a fixture. If you change your mailbox in the front of your house, when it's in the car at the Home Depot, it's personal property. You get a post hole digger, dig 3 feet under the ground, and put a 4x4 in there, and put Ready-Crete around it. When the Ready-Crete firms up, you nail the mailbox on top. That's a fixture. So it was a personal item when it was in your car. But now the way and manner it's been attached to the house becomes a part of the house and it cannot be removed. Now, in the listing agreement, if you state ahead of time, the front door, that hand-carved door, is not included or will be replaced, that's okay, if you say it ahead of time. Or in the contract of sale, if it says chandelier to be replaced by a new fixture, that's okay. But if the seller doesn't say that, then what the buyer sees, the buyer gets. And that's why it's important to mention these things. They can be replaced, okay? Now, we all know what a fixture is, okay? Now, it's different, a trade fixture, than a regular fixture. A trade fixture is a gasoline pump outside a gas station. A trade fixture is the walk-in box in a packaged liquor store. A trade fixture is a jewelry counter in a jewelry store. A trade fixture is the air conditioning unit in a deli. Those are called trade fixtures. Seats you sit on when you get your hair done. They're trade fixtures. Now, they're different trade fixtures than a regular fixture because in a trade fixture, even though they're commercial, the second ones are commercial. Okay, this is personal, more personal. The trade fixture, when it's attached to real estate by the tenant, can be, CAN, can be removed, provided it's removed before the lease expires. Okay? Before a lease expires. Once the lease expires, anyway, let's suppose you buy my bicycle business. And you say, Frank, $100,000, I have $40,000. I cannot get the $60,000 balance. No bank wants to give it to me because of security. God forbid, they're not getting paid. It's going to be hard for them to sell a bicycle business. Is there any way we can make this sale? I say, yes. If you give me that good down payment, you could pay me every month. Okay? That's called a chattel mortgage. Now, the reason it's called a chattel mortgage is the security is not on real estate. It's on the personal property. It's on the bicycles and all. So if you stop paying me, I get my bicycles back. So a chattel mortgage is a mortgage that's based, that the security is not on real estate, like when you buy a house, okay? Because if you stop paying, you and I know, if we stop paying our mortgage, the bank could have a sheriff's sale and they take the house back. With a chattel mortgage, it's the security is not on real estate, the security is on personal property. And therefore, if the person stops paying, the seller gets their personal property back. Okay? Ah. There are some countries that say a wife is a man's chattel, his personal property, and he could do with her whatever he wants. In America, he gets banged on the head by the ladies. What am I going to tell you?
It's the other way around.
A chattel. So a chattel is what? Personal property. A chattel is personal property.
What about corporeal?
Corporal property is what you can touch or feel. corporeal. It's one of the key terms in front of that chapter, corporal. You can touch the door of a house. That's corporal property. You cannot touch an easement that's in front of your house. That's incorporeal. Corporal, touch, feel, tangible. Incorporeal, cannot touch it, cannot feel it.
Embellments.
An emblement is an annual growing crop. You have to plant each year wheat or corn. That's an example of an emblement. Now, how it fits with real estate is this. Let's suppose that you're my tenant and I have a 5-acre farm, and your lease expires in August, but your crops are not ready to be harvested until October. And you come back to the property in October to harvest your crops, and I say to you, excuse me, you cannot trespass. Your lease expired in August. You could say to me, no. My crops are emblements. They're annual growing crops. On a one-time basis, I have the legal right to trespass on the property to harvest my crops. So in real estate, sometimes people can trespass legally. Another example would be if you sell your house and you have emblements on there, annual growing crops, tomatoes, anything that you need to plant and harvest annually. That's called an emblement. Now, if you sell your house to people and you do not get along with them, you want to come back to harvest your crops, they have to allow you to do it once. What? If you can prove in real that they are emblements, emblements, emblements. Take your time and tell me any words.
Parcel.
Parcel. Parcel. A parcel is a specific tract of real estate. Sometimes they will use the term, he's buying the parcel of real estate, or they'll say, he's buying this specific tract of real estate. So parcel and a specific tract are one and the same. Those two terms are used interchangeably. They mean the same thing. A parcel is a specific tract of land. That's what a parcel is. Take your time.
Okay.
No, that's okay. That's okay. I'm
So
fine.
we can move on to. I think
what-
we cover all the terms. I understand.
Okay, so
just by
how
reading.
about ownership in chapter 7? Ownership, is
Let's
that
go to the
a chapter
schedule.
that you'd like me to go over with you?
The way I like to think that now the real estate, we understand what we sell, what we do. We understand the restriction on
So
it,
you
different
want to look
value,
at it from the practical aspect of
From
the
a
time
flow.
it's a listing, the flow.
the flow, how
The
things
flow.
flow.
I understand that. So now you understand about what land is and what real estate
Now the
is.
next one is estate and interest.
Well, we covered that the first time. Remember we talked about freehold and non-freehold estates?
Right. There is an ownership and there is a non-ownership.
That's correct.
Right? And in the non-ownership is a lease and a 4 different type of lease.
Let's do it again. Let me just
No,
show
I
you.
got it. I
You
have
okay?
it. I'm
And then
okay.
we talked about what? Here, let's see if
We
you...
talked about different estate, fee simple, determinable, fee,
Perfect.
life estate.
Perfect.
Life estate, there are 3
Yes.
that, given to
Yes.
someone by giver.
Yes.
And it comes back.
Everything you're
and I
saying
can,
is right on the mark. Chapter
Right.
6, you see.
So I'm just going to go
And
to chapter
in that
7.
in that chapter are 2 other subjects. Liens and easements. Are you okay with liens and easements, or would you like me to discuss anything about liens or easements with you?
Let's discuss easement.
Okay, let's talk about easements in chapter 6, all right?
So easement is one of those land restriction.
That's correct. That's perfect. Yes.
Okay.
Now we need to talk about them, though. Okay.
So they are
let's-
mentioned in estate. Okay.
No, that's a total different subject, easements. All right,
Okay.
let's start from scratch. An easement is the legal right to trespass on the lands of somebody else, okay?
Got it.
I mean, in simple terms, it allows the public to go on somebody else's property. That's an easement. Now, we need to do is to discuss the types of easements in chapter 6. So, there's an easement by necessity. An easement, I'll give you an example, by necessity. Let's suppose you have something like this, public road, okay? Then you have this person, lot 4, he sells the back half to somebody else, 4A. But what he did not do is give egress and ingress so the owner of 4A can get on and off his property to get to the public road. The city, the town, would create an easement by necessity so that 4A can drive his car, get on and off his property. What you're looking at here is this.
By necessity.
You can't landlock somebody. You got to get him on and off his property. Now, another type of easement you might hear is an easement appurtenant. Here's an easement appurtenant. Anything attached to the land that becomes part of the land. And easement appurtenant. We'll get it spelled right, Frank. Easement appurtenant. A-P-P-U-R-T-N-E-T. Okay. Let's suppose that we have something like this. The owner of lot A and the owner of lot B. A and A's property, and this is the lake over here. A's property surrounds B's property. A's property is large enough that it goes like an L, reverse L. B's property ends over here. So A can, and his family, they can go directly behind their house to the lake. But B has to get in their car and drive around here to get to the lake. So B could make an arrangement with A to either get a license to go 3 feet behind B's house to get to the lake with their family, a shortcut, trespassing on B. So A has maybe a choice to give them a license or an easement. Now, when you get a question, and a license is temporary and can be revoked by the issuer. So if A gave B a license to go here and he didn't like what they were doing, he could reject that.
Right.
But an easement is more permanent. So one is more permanent, an easement is more permanent. A license is temporary. Temporary. Like when we go to a movie, we get a ticket to go to the movie, that's a license. Temporary. When the movie is over, we got to leave. We park our car in Bally's Casino. When we finish, we got to leave. That's a license. When you invite people to your home, you're giving them a license to come in. And if they act rowdy, you could ask them to leave. You could call the police if they don't leave. Why? Because they have a license. But over here, B may make an arrangement with A to get an easement for 3 feet over here. This would be an easement.
Got it.
Now, easements can be created by a deed. If A sold B the property, they could create the easement right in the deed, or by a separate document. Okay? Now, when you hear the term easement runs with the land, if A sells his property to somebody else, to D, this easement stays. If B sells his property to somebody else, whoever buys B's property gets it with the easement, which is more valuable because the family of B can have this shortcut to get to the lake instead of driving all the way around. So this is an easement appurtenant. An easement appurtenant runs with the land. Now, another popular easement for a test question that you're going to see is called an easement by prescription. An easement by prescription is when you park your RV behind my house. I have 6 acres behind my house. I look out the window, I see you with your RV. You're not trying to hide it. You park there. It's open, it's hostile, it's adverse, it's against my interest, but I don't tell you to move. Now, in New Jersey, if you do that for 20 years, you can go to court and get the permanent right to keep your RV behind my house. That's called an easement by prescription. So, in order for there to be an easement by prescription, it has to be open, hostile, adverse, and continuous. The continuous period in New Jersey is 20 years. Then you could go to court and I tell you to get your RV off my property. You say, Frank, I have a permanent right to keep my RV behind your property. I went to court. I have papers to show, I've documented, I proved that I was doing this for 20 years, whatever, and that's it. Now, an easement by prescription is very confusing because some people confuse adverse possession with an easement by prescription. Both of them require the same requirements: open, hostile, adverse, and continuous. The difference is with adverse possession, you could actually own the property of a neighbor. For example, let's suppose that you plant your garden 2 feet behind your property onto your neighbor's property, and they don't tell you to take your crops off. If you do that for 20 years, you could actually own some of your neighbor's property. That's adverse possession. So an easement by prescription is to use the property. Adverse possession is to actually own somebody else's property. And both of them require 20 years, open, hostile, adverse, and continuous in order to get that. Now,
actually, we own it. Adverse possession is owning.
That's correct. And years ago, they used to refer to that as squatters' rights, because the court said that land is so valuable, if we don't use it, we could lose it. So just because we have the deed to our land, if we don't use it, we could lose it. Now, there's 2 ways that you can cause an easement to come to an end. One way is where I give you permission 1 day a year, and I put a sign out. Harish, you can park your RV behind my house next, or I apologize, I stop you 1 day a year. I say next Wednesday, such a date, you cannot park your RV there. I stop you 1 day a year, like Rockefeller Center, New York. I think is chained off one day a year so people cannot go to Rockefeller Center. I think so. To stop, to prevent the easement from being created. Or the other way I could stop you is by giving you permission. I could say, it's okay to keep your RV behind my house. The problem occurs when the seller doesn't say anything at all, because in the minds of the court, the seller is giving permission, because prudent people would not allow somebody against their interest to do something. They would say something, but by not doing anything at all, in the eyes of the court, they are doing something. They're giving permission, even though they didn't verbally give permission. By their inaction, they're giving permission. That's the interpretation of the court.
Makes a lot of sense. A servient estate and a
Okay.
dominant estate.
Okay. When I gave you the example before of the lake over here, and the two owners around the lake, A and B, right? We said this was A, yes, and this was B, correct?
Mm-hmm.
And then A allowed B to get a 3-foot easement across A's property to get to the lake, yes? The owner who benefits from the easement is called
Dominant.
the dominant estate or dominant holder. Which one benefits from this 3-foot easement, A or B?
B.
Who- That's correct. And the one who's burdened by the easement, burdened. Who's burdened by the easement?
A.
A in the test question would be called
Servient.
so there's a dominant and a servient. It has to do with who's benefiting by the easement. In this example, B is benefiting, so he's the dominant estate. In this example, A is being burdened because they're letting somebody trespass on their land.
Makes sense.
Now, easements,
The liens.
let me explain before we go any further.
Right?
I think that you need to know how easements come to an end, okay? Now, easements come to an end when there's express release by the dominant holder. He signs a piece of paper giving it up. He says, okay, and then it comes to an end. Another way, here's how leases terminate. That's what I'm explaining. This is how. One way is for the dominant holder to sign a piece of paper giving up the easement. That's how it comes to an end. Another way is by the merger of the properties. So, if A buys B's property, or B buys A's property, the easement will come to an end. Another way that the easement comes to an end is by abandonment. So, if A can prove that although B had a 3-foot easement to go behind his house, he didn't use it. He used another shortcut with his family. Then this easement could possibly come to an end. And lastly, the easement comes to an end when the purpose for which the easement was intended no longer exists. And what would happen here is the lake would dry up. Then there is no reason for the easement. So these are the 4 ways that an easement comes to an end. Express release of the easement by the dominant holder, merger of the properties, abandonment, and purpose for the easement no longer exists. Then the easement's coming to an end. Okay. Now, as far as liens in Chapter 6, a lien is a benefit given to a creditor to go against the lands of the debtor and even force the sale of the house if they don't get paid. For example, if a person owes money to a bank and they don't make the monthly payment, the bank can have a sheriff sale of the house. Or people, why? Because in order to get the money, they had to agree that the bank could have a mortgage lien against the house. And then they can foreclose on that lien, the bank. And that's what they do by way of a sheriff's sale. But it's not just the bank. For example, if people own a credit, they don't pay their credit card bill. The bank could take that person to court, win in court the argument, get a judgment, and then get a lien, and then foreclose on that lien. And so it could be any creditor can force the sale of a house. Most of the time it's the bank that's forcing. But liens are broken down into two broad categories. Specific liens that go against a specific house, and general liens. So a lot of this subject matter in this course can be broken down into two broad categories. And liens are a perfect example. So there are some liens that
I thought it is voluntary or involuntary, general
also,
or specific.
That's a good point. I should have mentioned that. That's a very good point. For example, let's take a look at them. A voluntary lien. If you're borrowing $600,000 from a bank and the bank says in order for us to give you the money, you and your wife have to give us permission to put a mortgage lien on the house that you're buying. Would that be an example of a voluntary lien if you sign it, or involuntary?
Involuntary.
That's correct. But on January 1st of every year, there's a tax lien put on your house and my house. Do you want those taxes to be a tax lien on your house or my house? No, that's involuntary. So some liens are voluntary, where we give permission, and some are, they just put it on there. Okay. So liens here are broken down into two broad categories. Now, liens, again, are broken down into two broad categories: specific liens and general liens. Specific liens go against one house, like real estate mortgage liens, like tax liens, real estate tax liens, like mechanic or contractor liens. They go against one house. Assessments, they go against one house. Now, on the other side of the ledger, so these specific liens go against one house. Then on the other side, the general liens include judgments, IRS, and state taxes that we owe. Decedent debts, and corporate franchise taxes. The ones on the far right, the general liens, they go against everything you and I own, our real estate and our personal property. The ones on the left side go against one property. The ones on the right side, those liens, everything we own, and our cars, our houses, everything. And you're seeing the kinds of liens that covers. Now, the most popular one would be this first one, a judgment lien. I don't think there's too much more in liens. It's not too deep of a subject.
Right.
Now, I don't know about ownership, but I can tell you that in your chapter 7, ownership, you want to remember that the way a person owns real estate is very important. Because if we own it the correct way, we could protect ourselves from creditor attacks. If we own it the incorrect way, we could disinherit our loved ones. So it's important how we own real estate. And when it comes to ownership, there's a whole bunch of ways to own real estate. For example, timeshare is a form of ownership. A corporation is a form of ownership. Partnership is a form of ownership. A syndicate is a form of ownership. A joint venture is a form of ownership. A condominium is a form of ownership. A co-op or cooperative is a form of ownership. A townhouse. But having said that, in that chapter of ownership, there's 4 main categories of ownership. that you need to know something about. Let's talk about them. The first one is ownership in the severalty. Now, the word severalty is coming from the root word to sever or to cut off. It's not coming from the root word more than one. It's not coming from the root word several. It's coming from the root word to sever. So ownership in the severalty means ownership by one. Okay? And for the purpose of this, a corporation is said to own real estate in severalty, even though there's many corporate owners. So don't confuse it. You can't, just because there's a lot of people that own shares of stock in that corporation, if they own a building, that corporation is said to own the building in severalty. The law looks at a corporation as one. Now, another type of ownership is called joint tenancy. Another type of ownership is referred to as tenancy in common. And the last type of ownership, of the main ones, is tenancy by the entirety. And I'm going to explain these to you. Let me write them down first. All right. Now, in that chapter, there's a whole bunch of ways, as I explained, to own real estate: timeshares, syndicates, condominiums, but these are the four main categories. So let's talk about the first one. Ownership in the severalty has advantages and disadvantages. The advantage of ownership in severalty is that we don't have to ask anyone if we want to buy or sell the house. And timing is very important. Okay? And the disadvantage is we sink or swim on our own. We can't look to anyone to help us out. Okay? So that's a disadvantage. Now let's talk about the next type of ownership, joint tenancy. Joint tenancy is a special type of ownership. Let me put it over here, joint tenancy. Okay, now this one here is a special type of ownership with the distinguishing characteristic is that it, or the distinguishing characteristic being that it contains the right of survivorship. When I say survivorship, I'm talking about surviving joint tenants. I'm not talking about surviving loved ones or heirs. For example, if A, B, and C own a building in the neighboring town of Bradley Beach, and if A dies, A's interest will not pass to his loved ones. A's interest is going to pass to B and C automatically by this type of ownership. Okay, so let me repeat. The distinguishing characteristic of joint tenancy is that it contains the right of survivorship. It contains the right of survivorship. But what I'm talking about when I mention survivorship, I'm talking about surviving joint tenants.
Not
so
the heirs.
if A, B, and C own a building in Bradley and A dies, A's interest is not going to pass to his wife and kids. Right. A's interest is going to pass to B and C. So in effect, there's one less owner of that building in Bradley Beach.
Right.
Now, in order for this type of ownership,
so his share goes to B and C.
That's correct. So what you have then is something like this. You have A, you have B, and you have C that buy this building, yes?
Yes.
And A just died. So A's interest is going to pass to these two. Now these two are going to own the property as joint tenants. Okay? Now if B dies, then there's only one left. C. C is going to own the property in severalty. Why? Because there's just one left. It started out three, and now there's only one left. C makes a will and tells his lawyer, I want my daughter and my son, when I die, to own my property as joint tenants or tenancy in common. So it started out with A, B, and C owning the property. A, B, and C. A died No more. Now B and C own the property. B died. C is all by himself. So C then owns the property this way.
By severalty.
And C goes to the lawyer and says, I want to make my will. I own this house, this property, that property. I want you to put it in my will. When I die, I got a daughter and a son. I want them to share equally to own the property as joint tenants or tenants in common. So C determines that with his lawyer, goes to the lawyer, and they put it in the will.
And why does anybody will do this? Why?
Let's suppose that you get along with two friends, and you say to your one friend, you know, I know you from forever. We went to school together. What we do on a handshake is, but let's face it, I don't want you to take this personally, but if God forbid something happens to you, I now have to do business with your wife and kids. I don't know if that would be good in business. And he says to you, you know, I never thought of that. That's true. And the other partner says the same thing. So then they go, first of all, they go to the lawyer, and the lawyer determines how they should own the property. Real estate people, we don't get involved. We just say that you can own the property. But in what's happening is the lawyer, based on their needs, but let's say that they get along, but they're afraid they don't want to deal with the family members. Well, then they could own it maybe this way, because the death of one of the owners goes automatically to the surviving joint tenants. You don't have to deal with family. So that might be one of the reasons why people could own it this way.
And it doesn't happen. It makes sense, but how does it happen in practical way?
It does. Your question is a good question, because from a practical point of view, which is not in your textbook, the lawyers prepare a separate document. It's called a buy and sell agreement, which I'm sure you've had experience in your business life. And this document, the lawyer says to the three people, look, in addition to this, we'll have a buy and sell agreement. It does a lot of different things. It has, it puts the blue book figure in case of it's ever audited by taxes, what the property is worth, what happens when you get injured, but the most important thing is if one of you die, your interest is going to pass to the surviving joint tenants.
It's a separate document.
And what we'll do is we'll set it up in the document that will have the property appraised. And the two remaining individuals will own 100% of the building, and the widow of the deceased will get 1/3 of the value of the property when one of you pass away. Now the question is, where are they going to get the money to pay the widow? Well, a lot of times in business, they fund it by cheap term life insurance. So that if A dies, there will be hundreds of thousands of dollars given to A's widow. Now her husband just died. She's going to get back his investment and maybe make more if if the property is worth more in Bradley. So that the other two, B and C, own the building, and A's widow will get a check. Why? Because they crisscross life insurance. Okay, it's not mentioned in the book, but generally speaking, it would accompany, because if not, people would sue the lawyer and say, look, everybody else protects the widow, would go after the lawyer. So lawyers know that, and lawyers are going to protect the widow, because to just have not even the investment of the husband coming back to the widow, what kind of women are going to stand for that? The husband to put $300,000 or $500,000 in the building, if he dies, she doesn't even get that back? Where's the sense to that? You follow? Anyway, in this type of ownership, joint tenancy, it's only operable. Joint tenancy has to have 4 unities to make it work. And here's the 4 unities: time, title, interest, and possession. In order for joint tenancy to be operable, it has to have these 4 unities. I'm going to explain them to you. The unity, these are these are the unities. There are 4 unities in order for joint tenancy to work. If you don't have all 4, you can't do joint tenancy. Now let's talk about the unity of time. The unity of time. All 3 individuals acquire their interest at the same moment. You don't get A going to the lawyer on a Monday, B on a Wednesday, and C on a Friday. they did not adhere to the unity of time. The unity of title. They all acquire their interest from the same source, the same deed, the same life estate, the same will. You don't get A getting his interest from a will, B from a life estate, and C from a deed, no good. All three have to acquire their interest from the same source. The unity of interest, all three have to have an equal interest in the whole. So if two brothers own it joint tenancy, it's got to be 50-50. If three individuals own the building, it's 33 1/3%. Cannot be 60%, 20%, and 20%. If a test question says 60, 20, 20, then it's tenancy in common. Then it can be uneven. In other words, later we're going to talk about tenancy in common. There it could be okay, uneven. But if it's joint tenancy, the interest has to be equal. So when you see a test question and you see it's an uneven amount, and they use, one of the answers is joint tenancy, it cannot be joint tenancy because it's not subscribing to one of the four unities, which is interest, and the interest has to be equal. Two sisters not getting along, one buys the other out. They got to own 50-50 each. Now possession. They all own an equal right of the whole. So if you and your friend buy a 100-acre farm, you can't go to your friend and say, look, I'll farm the first 80 acres in the rear, in the front. You farm the last 20 acres in the rear. No good. If you and your friend buy the 100-acre farm, you're both equally allowed the equal amount of possession. Okay, so they don't take a knife or a thing and cut up the property. You farm here and farm there. Those are the four unities. Now, another type of ownership is tenancy in common.
Why they use the word tenancy?
Well, that's a good question. Okay.
Why not ownership in
That's
common?
a good question. Tenancy in common. Why do they use the word tenancy? The word tenancy and estate are used interchangeably.
Okay.
It means the same thing. So when you get a test question, they may refer to it as a tenancy, or they may refer to it as an estate. It means the same thing. It's the same thing.
It's not the same non-freehold tenancy as a tenant.
That's correct. Yeah, don't confuse it like a tenant in a lease. It's different.
Okay.
Don't confuse tenancy where somebody rents an apartment.
Correct.
Okay, tenancy and estates in land are one and the same. So, for example, when we talk later about leases, we're going to be talking about ownership. We'll be talking about the different ways people can have a lease, and sometimes it's referred to as an estate from years to year, or tenancy from year to year. So they'll use the word estate and tenancy interchangeably. Arose by any other word, it means the same thing, or it'll be say an estate at sufferance. That's where people don't get out of the house when the lease expires, or they'll say a tenancy at sufferance. Yes. We're going to do this one more night, and it will be free, by the way.
Oh, excuse me, I'm sorry.
No, I want you to know one more time, and that's it.
I'm just sorry.
Thank you.
Excuse me, thank you.
Okay, now, tenancy in common. Tenancy in common. She's a psychologist. I pay rent for this. I'm a tenant. I keep a little office.